Hello everyone, I'm Ankit and you're watching StudyIQ IAS English channel. Now recently there has been a big development in Indian polity. Madam President, she's asked questions to the Supreme Court of India seeking their legal opinion under the Article 143 of the Indian Constitution. So in our today's video, we are going to understand in great detail how this Article 143 functions, what options does Supreme Court now have, and how this will impact on a broader role on Indian polity. Now let us start our today's discussion by understanding the context of the news. First is that a reference has been made by the President of India to the Supreme Court using the power under Article 143, and under it Madam President has posed 14 different questions to the Supreme Court. And on a broader issue, these are related to the Supreme Court's judgment given in last month on the issue between Tamil Nadu governor and the government of Tamil Nadu. In the decision passed by Supreme Court, it fixed timelines for governors and the President of India to act on bills that have been given to them after being passed by the State Legislative Assembly. And she has sought the Supreme Court's opinion on what it thinks, because it has sought a timeline on President and Governor to make their decision. And in that case, you have to remember, because Constitution of India does not have any provision imposing them with the deadline to give the decisions on. So in that regard, let us first understand the background of this issue, then we'll cover Article 143. Now the background of this issue is based on a tussle between the governor of Tamil Nadu and government of Tamil Nadu on why the governor of Tamil Nadu was not giving his assent to the bills passed by the State Legislative Assembly of Tamil Nadu. Now this dispute automatically went to the apex court of our country, and our apex court in an April decision declared that the action of Tamil Nadu governor Mr. Ravi, who had reserved 10 bills that were passed by the State Legislative Assembly on Tamil Nadu, again, he reserved that bill for the President of India. And Supreme Court highlighted that this decision of the Tamil Nadu governor to reserve the bill, which has been again passed by the State Legislative Assembly for Tamil Nadu, to the President is actually illegal and erroneous. And under this regard, Supreme Court used its power under Article 142 to give what is known as deemed assent to the bills passed by the governor. So indeed, the governor actually did not give the assent, rather Supreme Court gave this assent using its extraordinary power under Article 142. And in this decision, Supreme Court made another important significant change. That is, it prescribed timelines on governor and on president that within a stipulated period, they have to give assent to the bills which are passed by the State Legislative Assembly. For governor, they had to give the assent in 3 months when the bills are first sent to him, and in a month period when it is resent by the State Legislative Assembly. And not just on governor, Supreme Court of India prescribed a timeline even for the President of India to act on the bills that have been reserved for it by the governor of the state. That is, it lays down a 3-month deadline on the President of India to give her assent on any bills passed by the State Legislative Assembly if the bills have been reserved for her consideration by the governor of any state. So this is the background of this issue. Now you need to understand there are many arguments criticizing and accepting the decisions made by the Supreme Court of India. First of all, many people agreed on the fact that guardrails that have been imposed on the exercise of governor's power was indeed needed, especially in the cases because in political context we understand governors are appointed by the central government, and if one party is ruling the central government and the state government is ruled by another parties, in many cases we have seen that the governors are locked in open and perpetual conflict with the elected state governments, especially if the state governments are ruled by party different than the one that is ruling the central government. So in order to ensure accountability and not to create obstacle in governance, Supreme Court imposed certain timelines on governor. But what was more controversial, because Supreme Court imposed a guideline and timeline even on the President of India, that even she has to adhere a deadline, and this actually limits her discretionary power that is provided in the Article 201 on the Constitution. And when Supreme Court imposed a deadline on the President, many people claimed that this was actually a judicial overreach by the Supreme Court of India. So this is the overall background of this issue. First is that Supreme Court used its extraordinary power under Article 142 to provide deemed consent on the bills, and also that Supreme Court imposed significant timelines on both governors as well as the President of India. So this is the broader issue based on which we are going to discuss Article 143. Now let us take the issue at hand, that is how Article 143 functions. So in that regard, what you need to understand, first you need to read the exact provision given in the Constitution, specifically under Article 143 subsection 1. So if you read this article, you will say that this power can be invoked by the President of India to seek the opinion of Supreme Court in any time if it appears to the President of India that it is related to a question of law or a question of fact. And this is not the question of and this is not just a question of law or fact that have already risen, but also it may arise in a near future. So in that case, she may ask for a legal opinion of the Supreme Court of India, particularly with a matter that deals with public importance. And hence the Supreme Court may refer this question for its consideration, and Supreme Court may, even after hearing such a matter, present a report to the President highlighting what is their opinion on the question that has been asked by the President of India. So this is what Article 143 essentially talks about, that it gives power to the President of India to ask any question relating to question of law or fact on a matter that has actually arisen or may even arise in the future. And Supreme Court, after hearing, it may also give the advice to the President of India. Now let us understand in detail how this actually Article 143 functions. Now this is an advisory jurisdiction of the Supreme Court that allows President of India to seek independent advice on certain constitutional matters. Now under the Constitution, you need to understand this is not a discretionary power of the President. Rather, President, she is acting on the aid and advice of the Union Cabinet. Similarly, it is the power that has not been invoked by the first time by the President. Rather, it has been invoked at least 15 times since the time the Constitution was enacted, that is in 1950. Now also, if you read Article 145 of the Constitution, you will see that any such reference needs to be heard by at least 5 judges, and after which the Supreme Court will return the reference to the President with the majority opinion. So this matter or the question that has been asked by the President, it needs to be considered at least by 5 judges of the Supreme Court, because Article 145 says so. Understood? So what we understood from this slide, that this is a matter relating to constitutional matter, and the President is not acting on her own volition, rather she is following the aid and advice of Cabinet. And this is not the first time this kind of a power has been invoked by the President of India. Rather, at least 15 times this has happened before since 1950. Now let us understand, is it mandatory for Supreme Court of India to give an answer or to give an opinion to the President of India? Now if you read Article 143(1), it states that court may, after such hearing, as it thinks that, might report to the President about their opinion. So if the word is may written here, that it means it is the court's prerogative or the decision whether to give reference or not. And you will be surprised to know that there has been 2 instances previously where Supreme Court has not given any answer to the questions posed by the President of India. And the most notable of not giving the answer to the President of India's case happened in 1993. At that time, India's President was Mr. Shankar Dayal Sharma, and he asked Supreme Court of India whether or not any Hindu temple or any Hindu religious structure existed prior to the construction of Ram Janmabhoomi and Babri Masjid in an area where this structure actually resided. Now this was actually a very political question that was asked by the President of India. So Supreme Court of India, it unanimously decided to not give an answer to this question. First, because this was a civil suit that was already pending before the court of law, and according to the Justice Ahmadi and Justice S.P. Barucha back then, it also said that this question violated the grounds of secularism, and therefore the kind of answer that the President of India then were expecting from Supreme Court of India, it actually was an unconstitutional question, because it violated the provision of secularism, which Supreme Court has already highlighted. It is an essential practice or a basic structure of the Constitution. Understood? So Supreme Court can and cannot give the answer, and we have understood it has not given an answer twice. The most important instance is on 1993, right? Now, what you need to understand, can Supreme Court of India overturn its previous decision of April based on the presidential reference? Now, the answer is no, it can't. Because if you follow the 1991 opinion given by the Supreme Court of India in the matter of Kaveri Water Dispute Tribunal, here the Supreme Court of India said that Article 143 is not the mechanism or not the way for executive to seek review or reversal of its established judicial decision of Supreme Court. So, the executive has other ways to seek for the review of the judgment, and they cannot use Article 143 to do the same. And here Supreme Court highlighted distinction between the kind of judgment that it gives. First is under adjudicatory decision, and this is when courts decide on something which is actually a legal dispute, and once the court gives its order in that regard, it effectively has the value of a law of the land, and therefore this is not a adjudicatory decision. Rather, Article 143, here Supreme Court is exercising its advisory jurisdiction, and when it is giving advisory jurisdiction to the president under the question asked under Article 143, it is a non-binding legal opinion without having the formal mandate of being a law of the land, or it does not have a legal value, same as the adjudicatory jurisdiction of the Supreme Court. So essentially what we understand from this side, that executive can't ask Supreme Court to review its decision under Article 143. It can ask them to review under different articles, not under Article 143. This is just Supreme Court exercising its advisory jurisdiction when they can give an opinion which does not have a legally binding agreement on the President of India. Understood? Now, is presidential reference asked by President of India this time only is only related to April 8th ruling of the Supreme Court of India? The answer you need to understand differently. Now, first is President Murmu. She has asked the Supreme Court based on different articles. First, she has highlighted that Article 200 and 201 of the Constitution, which deals with the decision made by Governor and President of India to give assent to any bill passed by the State Legislative Assembly. If you read the Constitution, it does not give any time frame for the Governor or President to act on these bills. Also, the concept of deemed assent that I've already told you, which Supreme Court gave under Article 142, it is alien to the Constitution scheme, and it fundamentally circumscribes the power of President and Governor, because we understand Indian Constitution provides for separation of power, and it is the power not of Governor and the President who forms an executive to give an assent to bills passed by legislature. And when Supreme Court of India is exercising its extraordinary power under Article 142, it is actually a decision which overreaches in the sphere of executive's decision making. So these are the questions that have been asked by the President under her references, and out of 14 questions, 11 questions are relating to these matters only. But if you read the last 3 questions, we'll start with question number 12. You'll read that the President has asked that in view of the Article 143 subsection 3, the Supreme Court must first decide whenever a case comes to it whether or not it deals with substantial question of the law, or whether or not it requires interpretation of the Constitution. If this Supreme Court comes at a decision that it requires substantive question of the law, or it requires interpretation of the Constitution, then it should constitute a larger bench, preferably a constitutional bench, comprising of at least 5 judges to dispose on this matter. And why this question was asked by the President of India? Because in the April 8th ruling, the Supreme Court gave this judgment based on the 2-judge bench. So in this regard, President Murmu has asked the question, when a matter comes to the Supreme Court and it deals with substantive question of the law, or it deals with interpretation of the Constitution, shouldn't Supreme Court constitute a larger bench of at least 5 judges, and it should not let a 2-judge bench give such kind of a decision. So this is the first question, that is question 12th, that deals with larger aspects of decision making, not particularly to the April 8th ruling. Now if you read the next question, that is question 13th, it gives reference to Article 142 of the Constitution. We understood this is a discretionary power of the Supreme Court to undertake complete justice, and therefore it provides an extraordinary power to the Supreme Court to deal with anything. So this President of India has asked a question whether exercise of powers under Article 142, is it only limited to matters relating to procedure law, or does it involve Supreme Court issuing directions or passing orders which are contrary or even inconsistent with the provisions of the Indian Constitution or any procedural provision passed by the Parliament of India. So the basic essence of this question is, can Supreme Court use its power under Article 142 to deal only with procedural law matters, or can it even go against the provisions of the Constitution and give any other judgment? Because essentially this is important. As we told you, under Article 201 and under Article 200, there is no time frame given in the Constitution for governors and president to decide, but Supreme Court has issued a timeline to these people. Similarly, under Article 142, there is no part in the Indian Constitution that says courts can exercise the power of giving assent to the bills, but Supreme Court did that by providing deemed assent to the bills, which was not actually given by the governor. So therefore, this deals with larger aspects of the powers of Supreme Court under Article 142. Now last is relating to question 14. Here the Supreme Court is defining the contours of central state disputes that can be heard by any court. Now the original jurisdiction of Supreme Court lies in Article 131. That is, whenever there is a dispute between central and state government that deals with question of law, this can exclusively be settled by Supreme Court of India according to the powers given under Article 131. But we read in the April 8th ruling, Supreme Court even allowed the states of the government or state governments with a right to seek writ of mandamus against the Supreme Court in case the president does not give her assent in 3 months period to the bills passed by them. So it actually opens another venue to the state governments under Article 32, that they can issue or they can approach Supreme Court of India, so that Supreme Court of India issues a right of mandamus, that it mandates president to make a decision if she has not taken a decision in 3 months time. So essentially it opens another avenue for state governments in case of central state dispute to approach Supreme Court, and it essentially violates Article 131. Okay, so these are the 3 questions that poses a larger question on the Supreme Court, not just relating to the April 8th ruling. Now, let us understand what is the broader context behind this presidential reference. First was the issue that Tamil Nadu governor case essentially roused out, that the relations between central government and the opposition ruled state governments. Now, we have seen not just this time, but even historical examples, we have seen that the governors of the state who are appointed by central government, they are seen to be undercutting the elected government of their state governments by refusing to give assents to the bill passed by state assembly. So, Supreme Court actually addressed this, and this is well and good, and it is accepted that governor should decide in a time frame. But while doing so, Supreme Court also issued timelines on the President of India, and therefore it violated the presidential discretion that is given to her under Article 201. So therefore, this is a bigger issue that has become a point of contention between the central government and the judiciary. Now, government officials, they have used this ruling to argue that the judiciary was actually undermining the powers of Parliament and undermining the people's mandate by overreaching the powers given to the executive of the country, right? So Attorney General of India, Mr. R. Venkataramani, he has said that President was actually not heard when this matter was heard by Supreme Court in April, and it passed a directive to the President without hearing her opinion also. And similarly, Vice President Jagdeep Dhankad has criticized this ruling, saying that India actually should have parliamentary supremacy, because India is a democracy. Here, people like you and I, we send our representatives to the parliament, and it is the representatives' job to pass the bill, and it is the responsibility of executive to deem assent to these bills. And therefore, India should have a very limited scope of judicial review. And when Supreme Court is actually overreaching to the powers of government of India, it is actually not adhering to the principles of separation of power, because what happens in separation of power? Legislature enact the bills, executive implements the bills, and judiciary deals with any dispute. Now, this dispute essentially was between legislature and executive. So why is judiciary overreaching with the powers of executive, and therefore it is violating the separation of power? So this is the opinion of the government. Understood? So in our today's discussion, we dealt broadly with how Article 143 functions. To conclude or to summarize, Article 143 allows the President of India to ask any question which is of important matter or for constitutional importance to the Supreme Court of India, and Supreme Court is not mandated to give a opinion to the President of India, because we have understood at least twice this has happened that Supreme Court has not given a reference or an opinion to the President of India because it was a contentious issue. Rather, does this question which is imposed on Supreme Court this time, does it solely deal with the April 8 ruling? The answer is no, because it deals with broader context of the Indian polity, that it deals with powers of Supreme Court under Article 142, it deals with powers of Supreme Court to deal with center state dispute, and it also deals with the ability of the government to decide on matters, because the provisions in the Indian Constitution does not mandate a timeline on the governor and president. So this is all for today's discussion. Now, before concluding, I'd want each and every one of you to solve this question. A similar question appeared in 2019 which was relating to Article 142. So I've changed that question a little bit to suit it for our today's discussion relating to Article 143. Now, which of the following is absolutely a correct statement under Article 143? Please let me know the correct answer in the comment section. And with this, we bring an end to our today's session. If you want to download the notes, these will be available on my Telegram channel. This is ATS Live, so you can either search it on the top right hand corner of your app, or also alternatively, you can scan this QR code and this will definitely take you to my channel. Subscribe to it if you still haven't and download the notes which will be made available. So this is all from my side for today. I'll see you again tomorrow. Until then, please have a very good night.